Hello, I'm John Hine, Director of Compass Resolution. Today, I have the pleasure and the privilege of talking to Richard Phillips. Now, I've known Richard for quite a few years. Not only is he a good friend, but also a great solicitor of 31 years' experience, held in high regard by his peers and clients, and recommended in a number of legal directories. Richard is a resolution accredited solicitor, a collaborative solicitor, and an accredited mediator. Welcome, Richard. Hello.
Hello, John. Good to be here.
Good to have you here. Now, Richard and I will spend about 30 minutes or so discussing the distinction between legal advice and legal information and where the boundaries lie. Our hope is that by the end of this conversation, you'll have a clear understanding of the difference between the two, or not. We'll find out. So, Richard, here's my first question for us to discuss, really. What's, in your view, is the difference between legal information, which the Family Mediation Council say I can give as a mediator to my clients, and legal advice, which I can't give to my clients? And let's just start with that one, if you may.
Yeah, it's a difficult question, John, as you know, and it's one that a lot of mediators, solicitors conjure with. I think, in my opinion, that legal information is giving more general information to people, information that they might be able to access, possibly by even Googling on reputable websites, doing some research by themselves, stating maybe general principles of law. Whereas with advice, it's very much more personalized. It's likely to be judgmental. It's going to be of opinion. And I think that that's where the distinction is. And it's very important, of course, that mediators give information in a neutral way, but they cannot advise. And that's very much the remit, of course, of the solicitor working alongside the mediation process.
So, I completely get that, and hopefully our viewers, and particularly those people going through separation, understand that distinction. But maybe we can explore a few examples that might help clarify even more for them. So I've got a couple of ideas, or a couple of scenarios I want to just talk through with you. So as a mediator, I've heard a number of mediators, who are also lawyers, to be fair to them, do this. They are working with a couple of clients, and the clients get stuck on a particular legal point that could quite clearly be kind of cleared up with some legal advice or information. That's what I want to talk to you about. And then what these mediators do, they say, I found for you clients, well, they say, would it be helpful, Bill and Sheila, let's say, if I can refer you to a case which you can find on Google or anywhere else, or Bailiff, a number of sources that is similar to your scenario, not the same as, because every case, obviously, as we know, is dealt with on its individual merits, but a case is similar that we can then discuss, Bill and Sheila, that might help unlock your thinking and where you are stuck on that particular issue. And then they give the kind of Bill and Sheila that case, or they may give them a guide about that case, and then they discuss it with them and help them to expand their thinking, their perspective a little bit from the legal perspective. They introduce some more information, I guess, and more knowledge that the clients would never otherwise have had about a particular legal case that might help them. Is that, what would you call that? Is that advice, information, or something else, another word you might use for that?
Well, I would say that's information, and it's helpful information, so the clients ultimately can make their own informed decisions. It's passing on information which is readily available, but they may not be aware of it. It's signposting people, isn't it? Rather than giving them advice, it's giving them the tools to make those decisions. And similarly, it might be, if we're dealing a question, say, of pensions, that it is perfectly right for a mediator to explain that there are different types of pensions, that they can be quite complicated, and again, referring perhaps to the Pension Advisory Group report, that very important document, advice that came out a couple of years ago, and of course suggesting that they speak to a solicitor, maybe involve a financial neutral maybe an independent financial advisor, an actuary, that type of person to bring in that expertise on a neutral basis. And that's doing really in my opinion, what a mediator should be doing, rather than just standing back a little bit. Otherwise, it's what assistance are you really giving the people in mediation? But it's not straying into advice and then saying, well, we've got this, and I think that the pension sharing should be this, that, and the other. But it's giving them the tools where they can then make those decisions, informed decisions themselves.
So it's kind of where the boundaries sit between making decisions for clients. I give them opinion, giving them a solution that they can then buy into, or helping them by giving them information, and quite a lot of information can be, but actually then making sure that they feel, and that you feel, of course, that they're making their own decisions, they're coming up with their own solutions. So I'm glad you. So taking that distinction, let's take the pensions, because you brought that up. That's quite an interesting one. So I've got quite a few cases where clients are saying, "Oh yes, but I built up a certain proportion of my pension, as we know, before the marriage." Should that be taken into account, the proportionate approach? Now, I know there have been some cases recently. So I, as a mediator who used to be a solicitor, might go as far as to say, well, there are some clear cases which I've condensed into guides on the current law that explains how the courts might approach that question, that I can share with you, because you can get hold of that anyway. And then we can discuss whether you think, based on it's the legal perspective, and what you also think is fair and what's reasonable, so how you want to do that. And so are you saying that if they're speaking to a solicitor, the solicitor might say, well, I think absolutely, based on current law, proportionality is right for you, and we ought to, and should be the solution. Whereas a mediator might say, well, that's the current thinking, but actually it's really important that you come up with make your own decision or solution. Is that the kind of distinction we're trying?
Yes, I mean, that's right. I mean, you are passing on information about the current law, but it's for them to tailor what agreement they want to come to.
Yeah.
And there may be times, of course, where, because we all have opinions, even as mediators, we're neutrals, of course.
Yeah. Yeah.
It's absolutely essential that we're impartial. But of course, we're only human. We're going to have things going on in our heads. But what ultimately we should be doing, of course, is helping them to come to what they believe is a fair outcome, an outcome that's going to work for them. But of course, and particularly if we're a little bit doubtful about whether that's an outcome that is actually going to be approved into a consent order, because ultimately, of course, in most cases, they are going to want to get it approved by a court. And it is going to be looked at by a judge to make sure that it is fair and reasonable. So if we had a situation, for example, as you give, John, where somebody might say, well, I built up all this pension beforehand, I want to ring fence it, and it may not accord with current law, then of course you're going to be saying it's important you do take advice, legal advice, particularly on those types of points, and possibly also point out that there is a possibility ultimately that a court may not see it, but provided both people are properly informed, that they are not under any undue pressure, then it is for them to put that agreement together. Of course, we can't make people get independent legal advice, but we would strongly be suggesting that that should be the case, particularly in that type of scenario when we might feel, I'm not sure whether that's something which is going to pass ultimately, albeit in the wide discretion of the court, a judge's approval.
So a couple of points I want to pull out of that, what you were to say, and it all makes absolute sense, as you always do. But the couple of scenarios I want to put to you, because this is what I sometimes do as a mediator. You might go, oh gosh, that feels a bit uncomfortable, whatever. but I know that as a former solicitor many years, but now practicing as a mediator, my job, apart from many other things, is to make sure that to ensure that the proposals my clients come up with, if assuming they want the judge to make it into a final binding consent order, which most do, of course, financial, that it falls within the kind of parameters of what a judge would endorse as a reasonable, fair kind of outcome. So I'm doing that as a mediator as well. So I'll say to my clients, part of my role is to ensure that when you come into mediation, that all the options we explore and the ultimate proposals fall within the legal parameters, i.e. it's legally fair, and so on. That's one thing I do. So I guess, and by the way, that's not to undermine what the solicitor would be doing as well, because you're saying actually it might be sensible also to take legal advice to make sure that what they're discussing falls in the parameters. I think there's a bit of overlap there, which I think. And actually, some clients would benefit in terms of confidence before they cross the line to go and have a meeting with a solicitor, which is why I recommend so many people to you, Richard, because you build their confidence so they come back in and make the decision for themselves. You know, when they're hearing someone with credibility and authority, with their best interests at heart, saying, yeah, you're on the right lines. You might want to think about this and do that. But actually, yeah, if you agree that, that's fine. They come in empowering this mediation and much more capable of reaching decisions themselves, which is, again, the point. That wasn't the point I was going to make, but I think it's a powerful one. But here's what I wanted to discuss with you. What about this? I'm exploring, I don't know, 4 or 5 different financial options with my clients. There is clearly one they're not exploring because it hasn't occurred to them, because there is a legal angle to it. Let's say, I don't know, they're talking about spousal maintenance or ongoing financial support from one to the other. And they're talking about how long, how much, and specifically the point I want to raise, which is at the end of it, let's say we know as lawyers, they have the option of it being a non-extendable period of time or extendable. They don't know that that's an option. And so I say to them, would it be helpful if I explain when you're perhaps suggest there may be another option you want to think about, or another branch of another option you want to think about, to inject a bit of law to expand again their thinking, their perspectives, to make sure they're considering those options and developing the option. Would that be, in your view, is that something that I could be doing, should be doing? Is that reasonable?
Well, I mean, I personally believe that you can do it, provided you're not saying this is the outcome, this is what you should be doing. You're trying to create another option for them. I know that, you know, it could be quite nuanced, and some people might think, well, hang on a minute, you know, you're trying to influence those people to come to a decision that you feel is fair as a mediator. And I know there is a danger of that. But I think with the safeguards in place, with time for reflection for those people in between meetings, of course, the ability to take their own advice, and ultimately that order going in to be approved by a court, I think there are a lot of safeguards in there. And I think that if you're not doing things like that, there is a question mark over how proactive and how helpful that mediator is being in trying to be creative and look at some other alternatives that perhaps haven't come to mind and may well unlock an impasse that they have.
Absolutely.
So I'm absolutely with you on that, but it's, as always, a question of language, isn't it? And how you present it.
Language, it's not so always the what, it's, well, very importantly, it's the how you do it. Absolutely. Whilst you're talking about that, yes, all the safeguards, the time to reflect, the time to take advice, the judge having to endorse it as fair, all those safeguards are absolutely in place. The mediator ensuring that you're falling with, that's all really important. But most importantly, as you say, well, I think as importantly as the what you're saying as a mediator, is the how you deliver it, isn't it? You know, and I know we're aligned with that because of your broad experience. Here's where I want to take us now, if you're okay with it. So we've talked about advice and information, and hopefully haven't confused our listeners completely, or the viewers, any of the public. But I think we're clear and we're aligned anyway. So that's amazing. Now I want to talk about the timing of when we give this. So there is often I'm hearing kind of two different kind of views about this, when to take advice. So there is a school of thought that says, well, actually, clients before they come into mediation would benefit from advice. And there's my school of view, or my school of thought, is that actually unless there's any urgent need, i.e., someone's dissipating assets, sending them abroad, or some safety issues, I would say, why not come to a neutral mediator, stroke lawyer, a former lawyer, first, to decide to have a view. And then actually what I often do is say to my clients, at that point, I think legal advice would be really useful. So when do you think there are, well, let's talk about the pros, the advantages and disadvantages of legal advice pre even coming to a mediator?
Yeah, I mean, again, it's quite a pertinent question. There are advantages if you go to a well-informed solicitor, hopefully resolution, accredited, maybe a mediator themselves, who is perhaps giving quite a holistic view and isn't becoming positional, and is perhaps to an extent fulfilling part of the role that may be a mediator, obviously with some distinctions, and can explain to the client about the process of mediation and the process options. Because, of course, if we must have a mediation information and assessment meeting, it isn't just about mediation. It's going to be what other process options does the client have. And if they come in well informed and supported by their solicitor into the mediation process, that actually can be quite helpful. And you may get through that meeting, quite reasonably well, without too much difficulty. The flip side to that, of course, is you may have lawyers who are still doing it simply. There are fewer and fewer of them, I'm glad to say, to simply tick a box. Let's get this off to court. But you've got to, because the law says so, have a mediation information meeting. And they've already been told, this is what you should be asking for, this is what you should be doing. And they're already quite positional, and maybe already taken against possibly the mediation process itself. So it really is dependent upon the person who's approaching the mediator and the advice that they've already been given. So I wouldn't say that I'm against people going to see a solicitor beforehand. It just depends on what information, what advice they've been given, before you have that first meeting.
I agree. I think the combination of that it can be very powerful if you've got a very holistically an assistant who approaches very holistically, keeps their clients' minds open, but informs them, helps them to make fully informed decisions and keep their mind open and so on. I'm getting, as a mediator, more and more. However, I'm getting more and more clients where they've gone to see a solicitor. The solicitor hasn't recommended mediation. The solicitor has cracked on and got involved in a lawyer-led process, letters backs and forwards, with all good intention of dealing with financial disclosure and getting some proposals off to trying to settle it themselves, not recommending for mediation. It hasn't worked. It's become quite polarized. They have become very frustrated that the other person's not disclosing what they should be disclosing, and the whole process has become lawyer quite polarized. I then get them as a mediator. They may have spent, typically the last 4 or 5 have spent between £5,000 and £10,000 and £15,000, having exchanged Form E's of financial disclosure, got nowhere, and they're quite polarized, and they're saying, well, the language is something like this: my husband or my wife is not cooperating, not engaging, and therefore, why should I bother? Let's go to court. And so they become quite entrenched already. Those are kind of scenarios that I'm thinking of as well. Is your view? Here's the question. I'm just giving you a scenario. Is your view that in most, and I don't want to put you on the spot, you might say some yes and no. Is your view that in most cases, again, assuming that there are urgent, where mediation clearly is not suitable, significant, I don't know, safety issues or and so on, or violence or abuse and so on. But is it your view that in most cases, clients the client comes to you as a solicitor, you give them some advice and then recommend mediation, go to mediation, or would you kind of take them on and say, no, I can help you settle this. We'll get a consent order very, very quickly. Let's deal with financial disclosure. What's your kind of approach there? And what do you think most solicitors would, how would they approach it when a client comes to see them? I know it's
Yeah,
very different because you're also a mediator, by the way.
yeah, sure. I mean, of course, I've always got, as a solicitor, mediation at the forefront of my mind.
Yeah,
As you say, John, if it's suitable
yeah, yeah,
and right in their particular situation, and no issues,
yeah.
as you say, of domestic abuse or a huge imbalance of power or dissipation of assets
Mm,
or allegations of hiding things,
yep.
um, and why not? And so I will be talking about that. The question is whether, even though I try always to take a holistic viewpoint and 360 degrees and trying to look at it from his or her shoes, as well, the opponent, inverted commas, or their ex, I should say. But that may still subconsciously, I might be giving a viewpoint which may not mean that it's entirely neutral, of course. And I think that there is something in coming into an initial mediation information meeting without a lot of knowledge, in a very balanced, impartial, neutral way, and a lot of information signposting. I know you're incredibly good at that, and all the information, John, that you've got on your website for people to go and look at for themselves, which is written in a very, very balanced way. And so I recognize that, even though I do my very best when I have clients coming to see me as a solicitor, that there probably is going to be a little bit of bias, possibly for them creeping in, however much I might try and hide it. So, is there an argument, or is there a point of saying actually you are better off going to speak to a mediator for the information meeting first of all? Yeah, there clearly is, and certainly with some solicitors, because as you say, people can come in and they're very positional, and it's even more difficult where they've come very late into it and they've started off. And there's been a lot of protracted correspondence. It's become very, very difficult and quite high conflict to then try and unravel all of that. It can do, and I know you're very good at doing that, but it is incredibly hard.
Mm.
Whereas if you can get people at an earlier stage, generally speaking, it can be easier. Although there may be that kind of war of attrition where people then are exhausted, unfortunately, having spent a lot of time, money, and energy to that point where actually they're now more ready to sit down, and to explore the options in a more considered way, rather than perhaps at the beginning when there's a lot of anger, a lot of grief, and really all the noise going on makes it very difficult, in fact, for them to come to mediation because of all the emotions that we all have when we separate.
No, I'm some really good points there, and I think what's coming out of this conversation, to me anyway, is the power, the positive power of solicitors understanding what mediators do, and mediators understanding what solicitors do, and working together for the clients, with a particular aim in mind, helping the clients actually resolve things as soon as
Mm.
possible. And so I guess it's coming more and more around to my thinking of, well, the kind of loosely a team, so you've got two people with a problem to solve: separation, finances, children, and
Yeah.
so on. And then they're thinking, well, how are we going to get through this as quickly, efficiently, cost effectively as possible? Who do I need to speak to? When do I need to speak to them? And then that's what we're talking about now. It could be a solicitor to start with, could be a mediator to start with, but whoever it is, the key is for the clients and the people they're going to see to understand where they are at any particular point in the process and who's helping them to do what, and actually with a common objective and purpose in mind. I think that's kind of coming out of
Yeah.
this. Okay, I think that's all clear to you and clear to me, and hopefully again clear to those watching. this idea of regulated and unregulated. Can we talk a little bit about that, just so kind of again
Mm.
the people watching who may not have any legal knowledge understand? So where the information or advice is coming from. So if it's a solicitor or if it's a mediator, can you what is regulated or unregulated?
Yeah, I mean, there are some examples of unregulated advice. There's a lot of information, of course, on the web, and it may not be proper legal advice. They may not have any qualifications whatsoever, and people need to be very careful of that. Obviously, solicitors are regulated by the Law Society. They have to do training, and
Up to date.
up-to-date training, of
Mm,
course,
mm,
and show those records
yeah.
if needs be.
Mm,
And mediators as well, if they are regulated by the Family Mediation Council, for example, by resolution, that they too will have certain standards that they have to adhere to.
sure.
And every 3 years or so, one has to reapply for accreditation, for example, and submit case studies and reflective um, uh, matters. I think that there is a risk, and maybe people, because of cost, which I understand, may go into getting information which really doesn't accord with the law. And ultimately, that's what has to be applied, because if they can't come to an agreement, sadly, then a judge is going to make that decision applying the current law. And therefore it is, in my opinion, very important that regulated advice is given. We're all aware of people, of course, who may have taken a half day's course in counselling. Well, we have psychotherapists who are incredibly experienced and have been in practice for maybe 30 years, very highly regarded, every qualification possible. So there are counsellors and there are counsellors, um, as there are, quite frankly, with solicitors as well. And that's no,
And mediators.
and mediators too, in
Mm,
terms of your experience and your
absolutely.
skills that you
Yeah,
have. And
absolutely.
therefore, I think it's very important that people do look very carefully at the solicitor or the mediator or the advisor, whether it's a financial consultant, and what their CV is and what experience they have. And if needs be, call them. Vast majority of us aren't going to start charging for a 10-15 minute call. And most people get a feel quite quickly as to whether they feel that person is knowledgeable, empathetic, understands what it is they need, and can give them information, and as a lawyer, appropriate advice. So I think that that really is important with all the stuff that does pop up
I
on the
totally
internet
agree.
nowadays.
And I think it's really key as well is to and clients generally don't do this. Maybe I'm not sure why, but I do. If I'm employing a professional,
Yeah.
wherever it is, ask questions. Can you tell me, are you a specialist in that area? Can you, and I don't mind people saying, how many years experience have you? Are you full
Mm,
time or part time? Are you accredited or not? Because obviously,
yeah.
clients don't actually necessarily know what questions to ask, but I would
Mm,
certainly be asking. And the other thing, and by the way, I did a little kind of section in my divorce handbook about what questions to ask the mediator
mm,
about accreditation. So it's really important. And then the other point you bring up, absolutely, I completely agree. Have a short meeting. Coaches call them discovery meetings. We call them pre-mediation. I have a phone call before my MIAM or
sure.
whatever it is. Some kind of confidence call. Get a sense
Absolutely.
of who you're speaking, because they're going to be your
Mm, mm,
guide, your supporter, your person giving you, working through with you. You've got to have a rapport, a sense of rapport. You've got to be confident. I think absolutely. Those
yeah.
are really good points. How are we doing with time? Let me just check on my time. Well, we're doing okay. Because the reason why I do that because I want to touch one last
Okay.
little area. Now this is kind of this question's come out of what's developing in the legal world, and I know Resolution are running a training program or training programs, so it's very early days for this. So we are both rusty and probably a little
Mm,
bit have gaps in our knowledge about this. But I just want to have a quick chat with you about this, and the subject's about neutral solicitors within the context of advice or information. Now, I've had a number of conversations with people who have actually been on the course, the early ones, or who are going on the course, and my question to them was, what can a neutral solicitor give their clients in terms of legal advice or information that a mediator can't? And if it is advice that a neutral solicitor gives their clients, how do they get around the question of a conflict of interest? Let's do with the first part first. Is there something, and it's really, this is, I'll put you on the spot, so I know you're not ready for this, and it's something we can just toy around, play around with for a couple of minutes, really. And I'm sure we get lots of calls in from other lawyers or mediators or something saying you missed this or it doesn't matter. But neutral solicitors, legal advice, information. What's your have you thought about any views about that at all?
I have thought about it. I'm obviously interested in any development that might help people who are going through a very difficult situation.
I thought you had,
So
yeah, well, you would.
yeah, so I welcome any option that might help people. I am reticent at the moment. I haven't signed up, although I would like to go on a course and make that call myself, whether or not I should also qualify as a one solicitor to client advisor. I think rather as perhaps you've hinted, John, I'm a little bit concerned about conflict of interest. I'm also would be concerned that anyone who's doing it, quite frankly, would really need to have the same skills as an experienced accredited mediator. And of course, go through, as I'm sure people are beginning to do now, very much a screening process, safeguarding process. Very important, of course, not to take on anything where there may be a significant imbalance of power, domestic abuse, hidden assets or allegations of that, and so on. And I think also to be checking in again, as we do in mediation, very regularly, that person, is still okay within that process, that you are, making absolutely sure that they're on board. I think rather like we might say in mediation that if we are providing information, that it might be information that sometimes somebody may not agree with. But if it's being delivered in a neutral way, and I often say this, is look, please, if there's something that I've said that you're not sure about, please ask me about it, because it's not because I'm being partial to one person or the other, but it's, my interpretation of what current law is stating about a particular fact. And so it might be, as we coming back to pensions, what the PAG report, for example, is generally saying. I think it is. I think there are dangers. I know that lawyers will have all sorts of signing indemnities and disclaimers and all sorts of stuff if people are going into that in particular. And I think it is going to have to take a particularly skilled lawyer to do it. I think there are other tools, though, already available, quite frankly. There is the early neutral evaluation, where, of course, either a very experienced barrister or solicitor could form a view, an opinion of what they feel might be a fair outcome. There are private financial dispute resolutions that we now do on quite a regular basis, particularly with all the delays that are going on in the court system. They can be very useful as well. And there are other ways. Okay, arbitration isn't quite the same, of course, but there are other ways in which I think that we can gather together all the information, and even if we're not going through the mediation process, we can put together in a collaborative way. There may be a very valid point. There may be some points about inheritance and how far it should be taken into account, excluded, of that nature, and people can't quite get there, but we understand what the other person is saying. I've had that kind of thing, on a regular basis on that type of point. But you're not getting involved in an aggressive exchange or a disruptive exchange for the clients. But you say, well, look, let's get somebody perhaps who can give us a viewpoint, and that we can do that in mediation, of course, can't we? As well, if people want that, or we might get a valuer in, an accountant. There may be a point on evaluation of a business or something like that. So I think that there are, in my opinion, other ways in which we can kind of get to that kind of one solicitor, two client point where, is it actually required? But I'm not dismissive of it, and I need to go on the course and I need to learn a bit more. I'd like to talk more about people, because it's very new, of course, who have actually been through it, whether it's clients, whether it is, of course, the solicitors who are offering that and have actually been through it, and to see what they make of it. Because I do take the point, John, that you made a little while ago, about, well, how far can you give advice and how far is it information that you're passing on, and then leaving the clients to make that informed decision ultimately, rather than actually saying, well, look, in my opinion, this is what you should now be doing.
Again, some great points there. And one thing that does occur to me is that if I'm a client and I'm going to a neutral, I and my wife are going to a neutral solicitor, one thing psychologically that would be of benefit is to know that they are a solicitor. The point you made, that they are experts in the law, and if I and my wife are saying to each other, we're okay. What we need is a fair outcome, fair in law. We need someone who can help us get to a fair financial outcome, who's up to date in the law, who has credibility, who's has a practicing certificate, who's updated on their training. I can see absolutely how that might be quite appealing to me, as opposed to going to a mediator who may not also be a lawyer, who may not be up to date, whose expertise is in facilitation and bringing together. And so I can definitely see that. But I tell you what's coming loud and clear out of this conversation is, if I'm here with my wife looking, and our purpose is to hold on to the decision making, and we need to choose who's going to help us, we have a number of choices. And actually, we rely on the professionals we're going to be speaking to work together to help us to achieve what we want to achieve. So if we go to a neutral solicitor and our conversation becomes very difficult, and the neutral solicitor perhaps isn't a mediator and that's skilled, they could bring in a mediator to help them, so that it becomes the neutral solicitor and the mediator helping. If the mediator is helping the clients and they think the clients need some neutral law, some legal advice, why not send them to a neutral solicitor? And so again, it's this kind of team approach. We take the central purpose. I and my wife want to make our own decisions, whether we go to a mediator first or a neutral solicitor, depending what we need to get us to the end game, which is effect. So I think that's probably what's coming out of our conversation as well. Each professional knowing what role they're in, and what the objectives are that they're working together.
There's no one size fits all. I mean, another point about the neutral solicitor, which did just spring to mind, is it could possibly be a particular use where you've come to a mediated agreement. There really are, or it appears anyway, very few issues on it, and you might then want that neutral solicitor to draft a consent order.
I was going to come to that, actually. That's very good. I've done that. I've used that, actually. And in fact, I've recommended you to do that as well, consent orders. It's interesting. I'm not sure we've got time now, but I know there are mediators out there who are also drafting orders, who are also solicitors and so on. So that drafting of the order, but I think it's because we could have another session. Maybe we will. Maybe we'll have another session on the drafting of consent orders and different options that face clients, because can be, just as we bring it to an end, really, I guess this can be a confusing world for those watching this. People who are going through separation, faced with so many options, and they are very reliant on you, solicitor, me, mediator, whoever else they see, coaches out there, to help them basically achieve what they want to achieve, fair outcome if it is, fair financial outcome, and so on, in the most cost-effective, least distressing, managed way. And if we're all working together, whether they come to a lawyer, mediator, and so on, all working together with that, then I think we're doing our clients a service. Certainly. It's for us to be
up to date, whether we're a family lawyer, whether we are a mediator, having that experience, having a few grey hairs and wrinkles can help. We've lived a bit of life, and to inspire that sort of confidence in our clients to come up with the best solution for them.
Yeah, I think a bit of I talk about grey hair. Just as we bring it to an end, which I'm glad you mentioned that. Thank you very much for highlighting
I
our
know,
favourites.
I can say it, John.
Yeah. Look, anyway, look, Richard, it's been an absolute pleasure, as always, talking to you. I'm hoping that our viewers will find this interesting. I certainly did. I always do, and fun. I'm hoping it's been useful and will be useful to my viewers. They'll find this on my website, but if they want to get hold of you directly, directly, I know I recommend my mediation clients to you, but if they want to get hold of you directly, just a quick plug. Why
No,
not?
sure. I mean, of course, I can be Googled, Richard Phillips, solicitor, Machin's. I'm
Excellent,
found,
excellent firm. Yeah,
yeah, Machin's,
it is. It is.
and yeah. So happy to help in any way that I can.
And thank you very much, Richard. And they would be well served, anyone who does see you. And you can also be found on LinkedIn as well.
Sure.
So thank you very much. I'm going to bring this to an end, and I'll see you very soon. Thanks again.
Yeah. Thanks, John.
Thanks for your time.
Bye-bye. Bye.
Bye.